Hello, my name is Andrew Nyamayaro. I am a solicitor at Tango Solicitors. So, if you make an application to the Home Office may straight away make a decision and allow your application. The Home Office may send you an email or correspondence to ask you for additional information. And the Home Office may refuse your application. It's important that you keep your contact details up to date with the Home Office. So you need to make sure that they've got your current email, phone number, and address. I know that for various reasons, some people advise or think that not giving your Home Office your contact details, particularly your home address, is in their favor, because they say that the Home Office will not be able to locate you should they want to come and deport you or remove you from the UK. But equally, it might mean that when they send you any correspondence, you will not be able to see those correspondences. So you have made an application to the Home Office and they have refused your application. What do you do? That question depends on the nature of the application. It also depends on the route that you are applying the visa from. There are different visas that are out there. You have got family visas, points-based visas, which include skilled workers and students. You've got protection applications. You've got human rights applications. Either way, each route has got its own way to challenge it. So, in most cases, when you've submitted a human rights application, which covers family-based applications, medical grounds, human rights applications on any reason, and if they refuse your application, the chances are they will give you a right to appeal that decision. So you will normally follow the appeals process. Unless if the Home Office has certified your application is clearly unfounded, then you cannot challenge the Home Office on as an appeal. You have to find alternative means, either submitting a new application or during doing the judicial review, which I'm going to deal with later. For you to submit your appeal, the Home Office would have given you the right of appeal to appeal, and the road that you are on is entitled to have an appeal. Usually there's a court fee to pay, unless if you've got a reason why not to pay. For example, you cannot afford it, or you're under legal aid, or there's a fee waiver of some sort that has been applied. But normally there's a court fee to pay. And again, when it comes to appeals, it's either a paper-based appeal or a face-to-face appeal. You have to choose the correct appeal depending on the circumstances. If there's factual issues, credibility issues, then it's best to have an oral hearing rather than a paper appeal. A paper appeal is £80, and an appeal face-to-face is £140. Then you have to follow the processes that are involved in an appeal, which I can make a presentation on a separate day, on a separate note, on the process that is involved in the appeal. Another way to challenge the Home Office is by administrative review. And this is particularly applicable when it comes to points-based applications. And points-based applications include applications for skilled workers, Tier 2, Tier 5, and so forth. It also includes students. So where your decision has been refused, as a skilled worker, as a student, mainly, then you have to follow the administrative review process. The administrative review fee is £80. And by the way, all these applications are done online. For administrative review, you are saying that the caseworker has made an administrative error. You are not challenging the prospects of the case in succeeding on appeal, or has done in an appeal, but you're saying there's an administrative error. Another caseworker could have come to a different decision as compared to what the caseworker did. Maybe they missed a different part of your evidence. Maybe they didn't consider what you explained, and so forth. They made a mistake administratively, so you have to do an administrative review. Both an appeal and an administrative review, you've got an important factor on your Section 3C. They automatically extend your leave to remain in the UK pending the consideration of the appeal and the administrative reviews. In my experience at the moment, appeals are taking long, around 12 months mark for most appeals or more. Likewise, administrative reviews again are also taking long, almost 12 months or more. So you have to make a pragmatic decision whether or not to pursue an appeal or an administrative review, taking into account all the factors in your case. Do you want the case to, or the person who is being affected to, say for example, come from abroad as soon as possible, so that maybe it's much better to do a new application rather than to go on appeal or administrative review? What is the evidential problems in that case, and so forth? What are the costs involved in the new application, and the costs and times are involved in the appeal or the administrative review? With administrative review, likewise in an appeal, it's not a chance for you to normally add new evidence, although there are grounds and circumstances in which you can add new evidence and information. And particularly with an appeal, if it's a new ground, then you might have to seek the consent of the Home Office for them to be able to say yes, it can be considered by the court, or you have to make a fresh application or a new application altogether. So far I've commented on two ways in which you can challenge the Home Office on their decision. The first one is an appeal. The second one is an administrative review. Then the third one is called the judicial review. And with the judicial review, you are making a challenge to the Home Office, because the Home Office is a public body and it makes public law decisions as well. So you are saying to the Home Office, you have made a decision that is maybe not fair, not proportional, that is too harsh, and that is unreasonable, and you've exceeded your powers or have not exercised your powers properly as in a public body. So some decisions of the Home Office that do not have a right of appeal or are not entitled to the administrative review may be challenged under a judicial review. Decisions such as a decision refusing someone entry clearance as a visitor, where a decision has been certified as clearly unfounded, where the Home Office is clearly exceeded its powers or has not applied its own guidance, policies, and laws. In such cases, it will be prudent to then seek judicial review. With judicial review, you need to be very careful, especially for lawyers like myself. We know of lawyers that have been referred to the regulatory bodies because the court has deemed that the lawyers have not acted professionally or have assisted the clients in abusing the process of the law. And another thing to note with the judicial review is that if a decision is made against you, then the Home Office is entitled to costs. And costs in the upper tribunal or in the High Court are very high. So it might be that you might end up with a cost order of not less than, under normal circumstances, £2,000, £3,000 or above, depending on how long and how complicated the matter is. So the issue of costs, you need to consider it when you're going for judicial review. And the issue of prospects of success, you need to consider it as well. There's a court fee off my head of £160 when it comes to judicial review, and it's not an easy process. The first process in the judicial review will be to do a pre-action protocol, which is a letter before action, which you send to the Home Office to say, hey, we are aware of the decision that you've made. We are not happy for ABC reasons, but we are giving you a chance to consider your decision and then give us a good decision. The Home Office might say, yes, we agree with you, we ought to overturn our decision. They might say, no, we do not agree with you. Or they might say, we are sending back the file to the caseworking team to reconsider the decision. Or sometimes they just remain quiet. You have to know that when it comes to judicial review, it takes around, you have got 3 months less 1 day to submit your application to the court. So when you're doing your pre-action protocol and everything else, evidence gathering, bear in mind the deadlines. And if they don't reply, don't wait for the reply, because it might come after 3 months, but you need to submit your judicial review in time. Otherwise, it will be bad because of being out of time. So you need to consider all those things as well. And you have to use the correct forms, the correct processes. And if you're not aware of what to do under those circumstances, that's where Time Law Solicitors comes in. We've got lawyers that are experienced in appeals, in judicial reviews, in administrative reviews, and they can tell you on your prospects of success, costs you're likely to face, the evidence that you need, and help you all the way through the process with our lawyers, solicitors, and barristers. So if you need help, contact Time Law Solicitors and we'll be able to help you. You can contact us on the details on the screen, or you can also deal with us in accordance with your circumstances. Thank you so much. This is Anko Nyamayaro from Time Law Solicitors.